Hi everyone, my name is Crystal Alanis and I'm an associate with Reddy and Newman PC, and I'm here with one of our partners, Rebecca Chen, and today we will be going over some of the common questions that we have been receiving lately and then open it up to your general questions. So you can go ahead and start typing those out now, and then we'll get to those towards the end. So I guess we're just going to jump right into it here.
Yeah, so we're going to, at the top here, go over some of the more common questions that we received, especially from last week's Facebook Live or during the past week that we haven't been able to address yet. So Crystal, one of the most common questions we've been getting is what is happening with the updated STEM OPT guidance that USCIS posted on its website?
Right, so as of now, nothing has occurred. As many of you know, as Rebecca said, USCIS recently updated its webpage with a new interpretation of the STEM OPT regulations as it pertains to the employer-employee relationship. So USCIS is actually now stating that to meet the employer-employee relationship requirement, the student must be working at the company's actual location and not at a third-party work site. Now, we have not seen this interpretation implemented as of yet when individuals are trying to obtain their STEM OPT extension, but we do expect to see RFEs on this issue, and we will likely see those issues on maintenance of status. So what might occur, or what might end up occurring, is that the H-1B will be approved without the I-94, meaning you will have to go to the consulate for visa stamping.
Right, so is this a recent change by USCIS? Have they, most of the news about it started circulating kind of last week, but when did USCIS actually update its policy?
It was updated in January and nothing has occurred to date, so we think it's just a way to issue new RFEs for this CAP season. But once we start receiving those RFEs, we will let you know more. But like I said, as of now, nothing negative has occurred.
Right. So we can't really recommend any particular action right now. We're just trying to educate our viewers, educate employers and employees who may have applications that are affected, so that if there is an RFE on an H-1B application later, it's not a complete surprise, hopefully.
Right. So another big thing that's kind of been in the news lately is the H-4 EAD in light of the letter that was issued from the USCIS director to Senator Grassley. Can you talk a little bit about that?
Yeah, so this was also in the news last week on the fate of the H-4 EAD. It was mostly as a result of the publication of a letter from USCIS Director Francis Cizna to Senator Charles Grassley. The letter was actually dated April 4th, but I think it was just published last week and then kind of circulated. So the purpose of the letter was the USCIS Director's update to the Senator on what the agency has been doing in order to bring USCIS in line with the President's Buy American, Hire American executive order that was issued last year. So among those efforts that USCIS has been implementing to carry out the goals of that executive order, one of those efforts are the intention of the USCIS to propose the elimination of the H-4 EAD. So it is clear that the USCIS director intends to promulgate regulations that eliminate the availability of the EAD for H-4 visa holders. However, the letter itself does not put anything into effect. I think a lot of people read the news last week and thought this is a statement by the USCIS director getting rid of H-4 EADs. We got a lot of questions. Is my H-4 EAD still valid? Can I still apply for it? Even though it was a statement by the USCIS director, it was merely a statement of intention. The USCIS director cannot himself unilaterally get rid of the H-4 EAD. It requires a proposed regulation, a proposed rule, which then requires a notice and comment period, and then they need to review those comments before they issue a final rule. That whole process can take 6 months at least. So we're going to have a lot of notice and an opportunity to respond before the H-4 EAD actually does get eliminated. So right now, anyone who has an H-4 EAD card, it is still valid. Anyone who has a pending I-765 application for an H-4 EAD, it is still going to be processed. Anyone eligible for it should still apply right now. What we're thinking right now is that the agency will propose this rule in June. That is in line with their prior statements. June was when they were going to kind of update what their next move is on the H-4 EAD. So we believe that elimination of the H-4 EAD may be announced in June, but like I said, it won't be eliminated immediately. It will likely be a several-month process before the final rule gets put into effect.
Okay.
Okay, so Crystal, if the H-4 EAD regulation does go into effect, can USCIS revoke an already approved EAD card?
They can. We just don't know what's going to happen yet. But we think that it is unlikely that USCIS will revoke an already approved H-4 EAD once the new regulation is in place. USCIS will likely allow those with an approved H-4 EAD to continue to work until that EAD is expired. But then the individual will just not be able to extend after that.
Right. And then another common question we get related to the H-4 EAD is if someone has the EAD card and they're trying to renew it once they have filed the I-765, if their previous EAD has already expired, are they able to continue working based on that pending renewal application?
Right, so no, you should not continue working if your previous EAD has expired and you're waiting on that extension of your EAD. You have to have the card in hand.
Right.
Okay, so another thing we've been observing recently is increased scrutiny on H-1Bs and the enforcement. So can you talk a little bit about that?
Sure. So in general, definitely there has been an increase in enforcement activity by the Department of Homeland Security, which includes USCIS. So USCIS field offices have announced increases in hiring to their fraud detection unit. We have observed an increase in the rate of compliance reviews and site visits that are being done for H-1B, not just the beneficiaries, but also for the H-1B employers. So it's becoming more common for USCIS to conduct site visits or send compliance review emails or do phone calls to check basically whether the terms of the approved H-1B petition are still in effect. If the H-1B beneficiary is continuing to work at the location that is listed in their most recently approved H-1B application, if his or her salary is in line with what's listed in the H-1B petition, if he's performing the job duties that were listed in that application. Kind of along those lines, something that we have been, it's not a new thing, but something that we've been emphasizing more recently is that amendment applications for H-1B work location changes need to be filed and pending with USCIS before the H-1B beneficiary actually changes locations. It's similar to a transfer situation where the application needs to be filed. It doesn't need to be approved for the beneficiary to change work locations, but it needs to be filed before the work location change occurs.
And we've actually been receiving RFEs on that issue going back to the previous petitions.
Yeah, exactly. So for extension applications or amendment applications with the same employer, you may think, oh, I've already gotten an H-1B approved with this company. This is just a renewal or an amendment. It shouldn't be too much of an issue. Actually, because USCIS last year announced that they are no longer extending deference to previous approved applications, they're treating each new application, an extension or an amendment, even if it's with the same employer, they're treating it as a new application, looking at it anew, and even looking into the prior application to see if the beneficiary has been maintaining proper status when deciding whether to approve this amendment or extension. So, like Crystal said, we've been getting RFEs on extensions or amendments where USCIS is looking at the residential address of the beneficiary. If the residential address on the pay statements or in the I-129 form show that the beneficiary has already moved to the city where the new work location is, that's an indication to USCIS that the work location change happened earlier than it should have, that it happened before the application was filed. So if you're in that situation, even if the H-1B employers or the client is pressuring you to move sooner, we really encourage you to wait until the amendment application is filed before the work location change happens.
Okay, thank you, Rebecca. So now we'll be opening up the forum to your general questions. Let me see if we can get them here. No, it's not.
This one? Okay, so, okay, yeah, it should appear.
Okay, sorry about that.
Okay, so, okay. So we have a question here on the processing time and general success rate of an MTR. So an MTR is a motion to reopen, also sometimes called an appeal. I assume it's the viewer Srinivasan that you're asking about an H-1B application. So unfortunately, if you're at the MTR stage for an H-1B, that means you've gotten a denial. And unfortunately, there aren't that many good options for the MTR or the appeal. If a motion to reopen is filed, it goes first to the service center that made the decision on the H-1B application. That service center has about 30 days to review the MTR and make a decision on whether they agree with the MTR argument. If they do, they can reverse their own decision and issue an approval. That very rarely happens, and so if the MTR is not successful with the service center, it gets forwarded to the Administrative Appeals Office, the AAO in Washington, D.C., and the appeal can be pending there for several months. I usually would say at least 8 to 10 months, but we've seen appeals pending for a year or more. Sometimes it's a very slow process, and in the meantime, filing an appeal or an MTR does not give you H-1B status and does not allow you to stay in the U.S. in a period of authorized stay or work. So just for the practical purposes of, or the impracticality of filing an appeal, unfortunately, even if you have good grounds for appeal, what may be more practical in your situation is to refile the application in premium processing with the same company or a different company that is more likely to get you back in status faster.
I have a question here. How many days are left to get H-1B receipt notices? I'm assuming that's for the cases filed in the CAP. So we should continue to receive those receipt notices through May, I believe, and then we'll receive the rejection notices in June, around June.
Yeah.
So they're trickling in right now, but they should continue to come in through May.
Yeah, it's kind of a slow process, especially since there's no premium processing again this year. So hard copy receipt notices, we have still been getting them. Even today we received some. So if you haven't gotten a receipt notice yet for your CAP subject application, there's still time. It's not over yet. Okay. Let's see. Okay. What are the chances of an H-1B approval for a programmer or a developer 2 with wage level 2? Okay, so this is going to depend a lot, actually, on whether the H-1B application is filed as a programmer or developer. Those are two different SOC codes that would be selected on the LCA, and actually the difference between the chance of approval for the programmer job title and the developer job title are very different. The chances of approval with programmer, which is, I believe, 15-1131 is the SOC code, chances of approval are very low for H-1Bs. That's even before last year. For several years, the chances of approval, I would say for computer programmers, 15-1131 has been pretty low. Developer SOC codes, especially if they are level 2, so a software developer, software engineer, something with that type of SOC code has a much better chance of getting approved, and that's because the OOH, which is the occupational handbook issued by the DOL, is pretty clear that for programmers, what they state as the minimum entry education requirements, it does not have a very good statement on whether a bachelor's degree is required for programmers, whereas for developers it has a much better statement on the minimum education that's required. So I would say for programmer, very little chance of denial. For developer, a much better chance, but we would still recommend going with level 2 as the wage. Okay. So Ashish is asking, is it a good time to go for visa stamping in India? Crystal?
Right now we're recommending that if you don't have to, do not travel. So unless it's an absolute emergency, just don't travel. That's the advice that we're giving. I know it sounds simple enough, but people continue to travel, and they have issues at the consulate.
Yeah, including people who apply through the Dropbox. So it used to be the case that applying for your visa through the Dropbox was a relatively safer option because you don't need to appear for an interview in person. If you qualify for the Dropbox, you just submit your documents through a Dropbox and then you would get your visa. It sounds like even Dropbox applicants are getting called for interviews now. The Dropbox has, or the visa interview waiver for the Dropbox has always been discretionary. So the consulate is within their right to call anyone in for an interview, even if they've applied through the Dropbox, and that seems to be happening much more frequently now than it has before.
And individuals usually get stuck in administrative processing.
Right.
And it can be for weeks, maybe even longer.
Exactly, yeah. So administrative processing, also known as a 221G, there's no set processing time on a 221G. You're not even sure a lot of the time what the actual issue is, why it's being issued, what has put your case on hold, whether it's a security check or an end client check or a check on your employer. It's very mysterious, and it could be pending for several months. You just don't know. Okay, so Anu asks, do I have to be living in the U.S. when my priority date becomes current to apply for the I-485 and green card? So, yes, so there are two ways to apply for the green card. One is the I-485, also called the Adjustment of Status application, and the other way is to apply for the immigrant visa through a consulate. If you're going to try to adjust status, then yes, you do need to be in the U.S. at the time the I-485 application is filed. It's the Adjustment of Status application, so you need to be in the U.S. already in a non-immigrant status in order for USCIS to adjust it to an immigrant. Okay, so Nandita asks, I have an approved I-140 and my visa expires next year. My visa extensions are based on the approved I-140 because she's passed her 6-year H-1B limit. If I switch to another company now, will there be any issue with the next extension?
So if you've already received an extension, then it's likely been approved for 180 days, and as long as the withdrawal occurred, if it occurred at all, after January 17th, 2017, you can receive another extension with your current employer on your H-1B. You'll likely get 3 years for your extension. Now, in order to eventually adjust your status to that of a permanent resident, once your priority date becomes current, you have to have started another green card process with your current employer.
And if someone does start the green card process anew with a new employer, are they able to preserve the priority date from the previous application?
Yes, you will be able to preserve that priority date.
Even if the I-140 is withdrawn, that
Right.
prior I-140. So as long as that I-140 was approved, the priority date can be ported to another green card application through a different company.
That's correct, yes. And that'll just, hold your place in line the earlier date.
Okay, so we have a lot of questions still on the H-4 EAD. Okay. How does an amendment, RFE, or approval/denial impact the H-1? Okay, so I assume it's a question on the outcome of an H-1B amendment, whether it gets approved or denied. What is the impact? So an amendment of an H-1B application, if it does get denied, if the previous H-1B application, basically the underlying H-1B petition, if that I-797 has not expired yet, that application remains valid. Basically, if you filed an H-1B amendment for a work location change, for example, to location B, that amendment gets denied, you're no longer authorized to work at location B, but if the application for location A is still valid, you can get back into status by returning to location A and continuing to work for the same H-1B petitioner there. Another option would be to file another amendment as soon as possible for location B. That would technically authorize you to continue working at location B. But an amendment denial doesn't affect, on its own, it doesn't affect the underlying H-1B. It still remains valid unless USCIS goes back and tries to revoke it on separate grounds. But they would need to send a notice of intent to revoke in order to do that. Okay, so we still have a lot of questions on H-4 EAD. Like we said, still valid for now, although we expect that an announcement will be made in June that USCIS is proposing to get rid of it. So actually, the statement in the most recent letter from the USCIS director to the senator didn't really have any new information about the H-4 EAD. We already knew from the government's regulatory agenda that they published in December that the government intended to eliminate the H-4 EAD. It was just a matter of when. And so far it's not yet, but likely there will be concrete steps toward that in June. Okay. Yeah. So Senthil asks, he has an approved I-140. How many years is that valid if he is outside the country?
Well, once your priority date is current, you are only given a certain amount of time to file for your green card. So it really just depends on the specifics of the case.
Mm-hmm. And then we still have other questions about selection of applications in the H-1B lottery. Someone is asking which happens first, the cashing of the filing fee check or sending the receipt. I would say almost always the filing fee check gets cashed first before the receipt notice is sent. The receipt notice is actually, it functions as a notice that your application is selected, but it also functions as a receipt, an actual receipt to the company to let them know that their filing fees have been received. So if your company used their own checks for the filing fees, they can also check their bank records. If the check that they used for your H-1B filing fee has been cashed, then that means your application was selected. And you can actually get the receipt number by getting an image of that cashed check. The receipt number will be printed on the back. Okay, how about Canada H-1B stamping, H-1B stamping in Canada? So our advice about traveling and getting visas stamping is really the same whether it's in Canada or any other country. We don't really observe a higher rate of approval necessarily at consulates in Canada. It's still going to be a pretty high level of scrutiny, a pretty high percentage of 221Gs, and a pretty high chance of denial. So our advice in general right now is to not travel if you do need to get an H-1B visa stamp. Okay, let's see. Some of the questions are pretty detailed, so we may not be able to answer them here. Okay, so Saudi is asking, how should we plan on moving from H-1B to H-4? Right, as the moment the H-4, it becomes invalid. So if you're filing a change of status application from H-1B to H-4, it is correct that once the change of status application is approved, the H-4 status goes into effect pretty much immediately. It will be effective from the date on the I-797 approval notice for that I-539 application, but most of that time that effective date is the same day that the H-4 application gets approved. So from the time that the H-4 application is filed, technically you're still in H-1B status and you can continue to work for your H-1B employer while that I-797 for the H-1B is valid. But once the H-4 application is approved, you're no longer authorized to work unless you also have an EAD that was issued with the H-4. So it is pretty much immediate. Once the H-4 gets approved, you're no longer authorized to work in H-1B status. Okay, so Jitendra is asking what would be the minimum or maximum processing time for verification on a 221G? Yeah.
What have we seen lately on the minimum amount of time it would take on those? We really don't know,
yeah.
Which is another reason we're advising not to travel. And technically, you know, the 221G acts as a denial.
Yeah. Technically, the 221G is considered a visa refusal and subject to the administrative processing outcome. Basically, if the consulate finds the information or evidence they need to approve the visa, it basically gets resurrected and approved. But the 221G actually acts as a refusal of the visa right then. So that's partly why there isn't really a set processing time that we can say the consulate will get back to you on, because it's not like an RFE even with USCIS or premium processing where they need to render a decision within 15 days. The consulates don't have a set processing time. I would say the fastest, in my experience, I've ever heard back from a 221G would be maybe a month, but that is pretty rare. I would say more common is 6 to 8 weeks, or in some cases, I think the longest one I've had is about 4 months. And the risk there, of course, is that if you're stuck outside the US for 4 months waiting on the outcome of your visa, you don't know if your H-1B employer is still going to have a position for you. Or in this case, it looks like this person's question is in the context of a client site. So if there's an end client involved, then an end client likely isn't going to wait about 4 months for you to return to the U.S. to continue the project. They're going to find someone else to get on that project somewhere in that 4 months. And if the consulate follows up with the end client at the 2.5 month mark, the end client at that point says no, or either they say that we don't know who that is, or they say he's no longer on this project. Either way, that means a visa denial because they couldn't confirm that the end client project was still valid.
And there's nothing even that we can really do from an attorney standpoint to move the process along.
Right.
There's no real way to inquire about the 221G and what's going on with your particular case. So that makes it a lot more difficult and more reason to not travel.
Right. So Srinivas is asking, that means elimination of the H-4 EAD is sure. The only thing is when. It does seem like at least the agency's intention to eliminate the H-4 EAD is pretty clear. That is definite, that USCIS is going to try to eliminate the H-4 EAD. However, we can't say for sure that it's going to happen until the final rule is issued, and there are a lot of steps, a lot of things that need to happen before the final rule is issued. Part of it is that the government is required to review comments from the public. Anyone who is invested in the H-4 EAD process, there's about a 2-month period where anyone can submit comments on any proposed regulatory change. So we do encourage anyone who is on the H-4 EAD or has family members who have the H-4 EAD, once that notice and comment period opens, send in your comments to the government. Let them know why it is not a good idea for the H-4 EAD to be eliminated. And we never know, there could be litigation or other steps that are taken to combat the government's attempt to get rid of the H-4 EAD. One of the things that I think would be a good basis for challenging the government on their intention to eliminate the EAD is that they can propose to eliminate it, but they need to show that there is a basis for their decision to do that. It can't be arbitrary and capricious. So, for example, even with the DACA situation, the government trying to eliminate EADs or the entire DACA program, there have been multiple challenges in the courts on the government's rollback of the DACA program, and those challenges in the courts have been successful. If you've been following it, the government has been ordered by the most recent federal court to continue accepting DACA applications. So we don't know for sure. We know that the government wants to eliminate the H-4 EAD, but whether it actually happens may be up to comments by the public, lawsuits, or other actions to challenge the government on this.
And this has to be really a push, from everybody's end, just like the DACA recipients were pushing, for what they thought was right. And it seems to be going their way right now.
Yeah. And the H-4 EAD has much more basis, I would say, in the regulation than DACA even.
Exactly.
I would say there's a lot more basis for making an argument to keep the H-4 EAD, at least legally. So I think we're going to end our session here for today. If we weren't able to get to your question, we apologize, but we will review the questions and see if we can consolidate some of them and answer them at the top of next week's Facebook Live session. I am Rebecca Chen, and this is Crystal Alanis. Thank you for joining.
Thank you.